level as the UN level. Before we begin, I wonder whether there's representative from the Secretariat of the Committee of Experts on the Rights of the Child. Jennifer, is there anybody? If not, we could just continue.
Not yet.
Okay. All right. So thanks very much. How we will proceed, we will hear from the panelists, and then we will get to ask questions. Please feel free to pose your questions on the chat box. Sorry, I need to introduce myself. My name is Anita Nyanjong, and I'm the regional coordinator for the Eastern Africa Child Rights Network, and I'm based here in Nairobi. So to start us off, colleagues, we know that the communications procedure is an important part of bringing complaints before treaty body processes. We know that in the context of Africa, we have tried using that procedure, and today we just want to understand how effective we can be. We can use that procedure, and whether that procedure is at all useful in light of the decisions that have been made by the committee in relation to that procedure. Also, we will get very detailed experiences from the UNCRC level. Child Rights Connect on board, and they will be able to share with us how we can explore that communications procedure, and how do we, how as civil society organizations, how we can work with also the Child Rights Connect in regard to exploring that process. So without much further ado, I want to invite the panelists. If you allow me, I will just share with you details about the panelists. We have on board Mr. Michael Nyarko. I hope I pronounced that your name well, Mr. Michael. Yeah. Mr. Michael Nyarko is a PhD candidate at the Center for Human Rights. We know that the center, has done immense work within the continent, within the African Union human rights procedures. Mr. Michael Nyarko, thank you for joining us, although last minute, but we do really appreciate your expertise, and we want to really learn from you today. So Mr. Michael Nyarko, apart from being a PhD candidate at the center, he is also a researcher at the litigation unit, and he has, published extensively on issues around human rights. Mr. Michael Nyarko, we do appreciate and thank you for joining this panel.
Thank you for having me.
All right, thank you. The other person who's on the panel is Miss Olivia Solari Yigoren. Olivia, I hope you're on board. Yes, Olivia, thank you. Thank you for joining us this very early morning. It's all early for all of us. So Olivia is a legal officer at Child Rights Connect. Child Rights Connect is also a very esteemed organization that works on child rights advocacy at the UN level. Olivia is a human rights law specialist. She's raised in Southeast Asia and Latin America, and has a master's from Essex, master's in human rights law from Essex, and she has also advised on human rights standards in social protection policies at the World Bank Group in Washington, D.C., and has also worked at the Office of the High Commissioner for Human Rights in dealing with gross violations of human rights. She's also worked in Peru, in Lima, and participated as a judge at the Inter-American Human Rights Moot Court competition of the American University. She describes herself as a marathoner. She's fluent in English, French, Spanish, Portuguese. Thank you very much, Ms. Olivia, for joining us this morning. So the other panelist that we have is Mr. Michael Marwa. So we have two Michaels on board. Mr. Michael Marwa joins us from Tanzania. experienced child rights advocate. If you allow me, I want to do justice to his bio as shared by him. Apologies for that. So Mr. Michael Marwa specializes in gender and development work and has a keen interest in child protection, youth development, and social justice, including sexual and reproductive health and rights. He has over 10 years experience in this field and is a well-sought-after professional at the national level and is well known for his advocacy in the field of child protection. He has overseen campaigns targeting local government authorities on budgeting for children's services. Michael is also a technical advisor to several national, regional, and international institutions on child rights programming. He is an expert. He is experienced in child rights advocacy, particularly child safeguarding, child-friendly budgeting, child rights governance, and has worked on child trafficking, child labor, adolescent sexual and reproductive health rights, including supporting in-state party reporting and civil society complementary reporting to human rights treaty body processes. He has also engaged in policy making, donor engagement, and project proposal writing. So, Mr. Michael Marwa, thank you very much for joining us to this panel. If you could just also put on your video for participants to see who they're speaking to. Then lastly, participants, we will also be joined by my colleague, Ms. Felicitas Motimedi. Ms. Felicitas Motimedi is the regional coordinator for the Child Rights Network for Southern Africa. She has extensive experience in regional advocacy. Later, speaking to us later during this.
Sorry, Anita. I think Arabic, please just stop and then call Dominique for now because we can't hear you and it's interrupting the conversation. Please just stop for interpretation right now and call Dominique. Thank you.
All right, thanks very much for that, Jennifer. So we'd like to begin this discussion. I think most of us have been waiting very eagerly to listen in from the context in Africa and from the context within the UN level. How do we use this mechanism more effectively? What are some of the challenges that civil societies are facing? What are some of the legal loopholes, in terms of admissibility? We've seen within the regional context some communications being dismissed for admissibility. How do we maneuver the loopholes around admissibility? Do those also apply within the UN level? Do we very interesting decisions emanating from the committee within Africa, whether, if a state party has not agreed to the Article 44, how do you still, how can somebody still bring a communication despite a state party not being not having agreed to Article 44? So we want to understand all these legal issues, and we have the best panel really to help us maneuver and understand how to work with the communications procedure. So hopefully at the end of this session, we'll be seeing greater collaboration among civil society organizations around how we can work together to use this procedure more effectively. So if you allow me, I just want to give this opportunity to my partners, to the Center for Human Rights, so that we can really understand, what is the communications procedure within the Charter on the Rights and Welfare of the Child, the African Charter on the Rights and Welfare of the Child. How does it happen? What are those legal issues? I know that the center has in fact brought communications to the committee what were those experiences, if at all, and what can we learn from that? And then we listen to Olivia to give us the context in the UN at the UN level. And then Mr. Michael Marwa from Tanzania will give us his perspectives as a practitioner, as a child rights practitioner, what he thinks around the issue of communications procedures. So, Mr. Michael Nyarko, you have the floor, please. Thank you.
Thank you very much for the opportunity. I think I will be a bit brief. I will try as much as possible to summarize my presentation. I'm told that I have 15 minutes, and this is something I usually do in an hour and a half. So forgive me if it seems a little bit too simplistic in some way. But the complaints procedure is essentially one of the avenues of holding states accountable. And we know there are other avenues such as the state reporting and urgent appeals or country visits, which the committee can use as a means of finding information and making recommendations to the state party concerned. But the complaints mechanism essentially allows individuals, civil society, even state parties, and in rare instances, even non-state parties are allowed to submit complaints to the committee to essentially bring to the attention of the committee human rights violations concerning children in a specific country. And in terms of who exactly can bring the communication, it's the rules are quite elaborate and, if you like, very liberal in that any individual, NGO, or even intergovernmental organizations, including agencies of the United Nations, may file complaints before the African Commission to seek redress.
Arabic, please stop. Go on, Michael.
Can I proceed?
Yes, go on, please.
Yes. So it's quite a broad liberal process where you can bring communication, whether there's a specific individual who is a victim, or if it's a systemic issue, which one would think that you don't need a specific individual, but that it's a general legal problem or it's a social problem within the country that needs to be addressed. That CSOs, without the need to actually have consenting victims, can still bring a communication in the best interest of the child, and if possible, that they are required to inform these particular victims. But that is not something that the committee is very, if you like, strict about, if there is no consent per se from the particular individuals who are the alleged victims of such violations. The complaints may be brought only against state parties who have ratified the African Charter on the Rights and Welfare of the Child. I suppose, unlike the UNCRC, there's no need for the ratification of an additional protocol, which happens under the UNCRC. But the victims must be individuals who had been violated within the state concerned. If you're talking about a personal jurisdiction, that these individuals must actually have been violated within a particular state. Of course, there are issues about extraterritorial jurisdiction and whether a state may be held accountable for something that happens on the territory of another state if that state had some control or was in charge of that particular region at that point in time, especially in conflict situations. But the factual circumstances of the case must raise violations that are specific within the African Children's Charter. So you must allege that a particular provision in the Children's Charter has been violated, and that that violation requires redress. You can only bring complaints against the state in regards of violations that happens after they ratify the charter. Of course, there is also the issue of continuing violation, so that if the violation occurred before the state ratified, but it's continuing into the period within which they have ratified the charter, you could still bring a communication to seek redress because of the continuing violation of this particular, violation of the victims, so that it's not retroactive. You cannot bring a case against the state which had already, stopped, the violation had already occurred before the state ratified the particular charter. The African court has an interesting dilemma on whether or not one could bring a case before of violation that happened before the state ratified, but the African court's situation is quite different from the committee. In terms of admissibility, I think it's very similar to the African Commission's admissibility requirements, that you must provide the name of the author of the communication. Of course, you are also allowed to request anonymity if there are specific concerns of security or reprisals that might be faced by the particular complainant. But once you send the communications to the committee, you must disclose who the author is. But you can request that the committee does not disclose the author to the state party concerned, so that the committee would, in their communications to the state party, anonymize the particular individual who is the subject matter of this complaint. And it must not also be manifestly ill-founded or groundless, so that there must be a real, basis for bringing the complaint. There must be an actual violation or a threatened violation, which has the potential of, causing harm to the victims in this particular case. And it must not be written in disparaging language, as is required under the African Charter as well. And there's also the requirement of the exhaustion of domestic remedies, which usually is the number one hurdle that most CSOs face when it comes to filing complaints before the committee. Because, ideally, you should have exhausted all the domestic processes. You would have gone to court in that particular jurisdiction where the violation occurred. And it's only when you have exhausted those judicial remedies available within the state that you would ideally be allowed to proceed to the regional level or to the UNCRC per se. But of course, there are many instances where, even without exhausting local remedies, we have been able to utilize the committee's communications procedure, especially if it is a situation of mass human rights violations. For instance, in the case that we submitted against Senegal, the Taliban children's case regarding street begging, because of the enormous nature of the violations, there were, in this case, about 100,000 children who were begging on the streets of Senegal at the time. And we made the case that it is perhaps unreasonable to expect that one would exhaust domestic remedies, for all these individuals before approaching the committee. And that if there are mass human rights violations, perhaps it is something that the state is well aware of. And if they actually wanted to take measures to address them, they would have. And that there's no need to try to exhaust those domestic remedies when the state is well aware of these violations and still haven't done anything about them. So in such instances, the committee is willing to exempt CSOs and individuals from exhausting domestic remedies, but also the usual availability and effectiveness or sufficiency of remedies, as the African Commission has usually expounded on. That if there's no specific remedy, for instance, if you are in a state where judicial review, for instance, cannot overturn a legislation, then one cannot expect that you go to court to do something that is impossible. So there must be available judicial mechanisms that are actually capable of resolving those disputes within the state. And if those are not available, then you can bypass the domestic remedies and go straight to the committee to seek redress. But there's also the requirement that whatever complaint you are submitting must not have already been settled under another international procedure. So, for instance, if the complaint had been submitted to, let's say, the UNCRC, for instance, then it's perhaps not appropriate to submit the same complaint to the African Committee because of the real possibility of creating confusion and conflicting, decisions, which now makes the rules unclear as to what exactly does the rights mean per se. The committee may request a hearing if there is not sufficient information that is provided in the complaint itself or the response from the state party concerned. But this is usually not something that the committee does all the time. If there is sufficient information based on the papers that were filed, they would decide the complaint based on the actual information that is presented without the need for a hearing per se. And there's also the requirement that as much as possible that the particular children who are the victims or who are affected by this particular complaint are given the opportunity to participate if this is something that it's possible and can be accommodated. In the process of determining this complaint, the committee has also the option of seeking for further information from specialized agencies like UNICEF, or UNDP, or other treaty bodies, even domestic NGOs, to find out what exactly is the situation within the country concerned. So it's really not limited to the specific, if you like, individual complaint that is submitted by the affected person. The committee can also look at the broad, systemic issues that may be involved here, and that could be an avenue of understanding much better the situation, to provide more comprehensive recommendations or remedies to the victim, but also to help the state party to better implement its obligations under the Children's Charter. In terms of remedies, if there are urgent issues that need to be addressed even before the case is determined, there is the opportunity to seek for provisional measures pending the finalization of the communication itself, so that if a child, for instance, is being incarcerated and deprived of their education, perhaps one could seek provisional measures to ensure that this child is still able to go to school and have an education whilst the case is pending before the committee. And that even though this is a provisional measure, it is in a way not a determination of the case itself. So it's like saying, well, we know there's a pending case and we are providing some protection for this child or children, whilst we're seeking to determine what is the veracity of this particular complaint. Also because children mature very fast, and if a child loses 3 years of their educational, career, for instance, because they're incarcerated, then they would have lost a substantial part of, their growing up. And perhaps by the time they actually get relief, they would have no longer been a child, and the same opportunities that were available to them as children might not be available. So that we can use a provisional or precautionary measures avenue if there are urgent issues that need to be addressed before the complaint itself is actually finalized. But the committee also has, in some instances, utilized the friendly or amicable settlement procedure, where the committee essentially facilitates an agreement between the parties. There is a case that the Institute for Human Rights and Development in Africa filed a couple of years ago against Malawi on the issue of child marriage, and the fact that the law was discriminatory against girls. Girls were allowed to marry earlier than boys, whilst boys were allowed to marry at 18, girls were allowed to marry at 16, which the IHRD felt was a violation of the rights of the girl child in Malawi. And in this case, the committee facilitated a settlement between the complainant and the respondent state, which agreed to actually amend the laws and bring them in conformity with the committee, the Children's Charter. And they actually did amend the constitution to raise the minimum age to 18 years, even before the time that was given by the committee elapsed, so that there are these other avenues that, beyond the strict contentious litigation, bringing a communication could also facilitate a kind of engagement with the state party to find solutions to child rights problems in the specific country. But generally, the committee can also make declaratory orders of violations and provide specific redress to the victims. In many instances, the committee has provided compensation to victims. There was a case of a rape allegation in Cameroon against a girl child which was never investigated nor prosecuted by the state of Cameroon, and the committee did award compensation to the victim and provided other kind of redress, including requesting that the state prosecutes the perpetrators of that human rights violation. So that's with a brief overview of the procedure per se. But in terms of why perhaps it's important to utilize the communications mandate, but perhaps before I proceed, initially there was an issue with whether a state, for instance, which has entered a reservation against the Article 44 procedure of communications, can still be a respondent to a communication. And this seems to have been addressed by the committee in a case that was brought against Egypt. And the committee now says that a reservation against the complaint procedure is against, what do you call it, the object and purpose of the charter itself. So that whether or not a state has entered a reservation against the communications procedure perhaps is quite irrelevant, and that CSOs can still bring communications against that state. I am not so sure about whether everyone agrees with that interpretation of the charter, especially whether state parties would agree to that. But as of now, that is what seems to be the reasoning of the committee, that if you enter the reservation against their ability to receive complaints against you, then you're essentially defeating the purpose of the whole charter. And accountability is an important part, signing up to these treaties. But this complaints mechanism is really an accountability mechanism and can be used, to bring out specific issues concerning a particular state. But perhaps it's also important in instances where a state party is not used to reporting, because the reporting mechanism perhaps is the broadest sense of the state itself doing self-introspection and allowing the committee to give it a recommendation on how best to implement the committee's recommendations or their obligations under the charter. But if a state party is not one that is used to reporting, perhaps a complaint mechanism is a way of actually reporting to the committee what it is that is a violation that is going on within the particular state party. But perhaps it's also useful in between reporting cycles, so that if a state is not reporting in a particular cycle and there are issues that are going on, one could use the complaint mechanism as a means of bringing certain issues to the attention of the committee. But it also allows the committee to elaborate on the rights themselves, so that if someone brings a complaint on the right to education, it allows the committee to think about what does the right to education mean in the context of the African Children's Charter, and what is the specific obligation of the state party. So it facilitates the development of the law itself, and enables states to better understand what exactly is the kind of obligations that we have under the charter. But it also allows the committee to provide specific redress for violations. So if a state is recalcitrant, for instance, in the Cameroon case where someone is a victim of rape and the state is not taking actions to ensure that the person who is a perpetrator is facing justice, that one could use this avenue to sort of force the hand of the state to act in a way that respects the rights of the affected individuals. Then perhaps one of the things that one could also benefit from using the complaints mechanism is the issue of international assistance, and this is something that the UNCRC perhaps is more specific on, that the committee can, for instance, advise the state to seek assistance from a particular entity or agency, and perhaps facilitate such kind of assistance where there are specific or systemic challenges which the state party is unable to address, and which others are more capable of assisting it to address. So, I mean, once the decision is given, there's usually a requirement of 180 days, that's 6 months, within which the state party must report back to the committee on the measures it's taking to implement these decisions. And perhaps that is one of the challenges of the the communications procedure, because it's not something that usually really happens, as in the actual reporting back on the implementation of the decision of the committee. But another challenge is the delays. Sometimes the communication can be pending for quite a long time. We submitted a complaint against Uganda a couple of years back on the issue of child soldiers, and the communication was only determined 5 years after the war was actually over. So that, I mean, the kind of violation that we were seeking to redress at the time had almost become moot by the time the actual decision of the committee had been received. So the delays can really be a challenge with communication procedures, but I can see that, I mean, in the recent past, the committee has been more, urgent in how it approaches this kind of complaints, and perhaps it's from past experiences. But I suppose one thing that the committee could also do in terms of following up on implementation is to use the state reporting process as a means of following up on what the state has done to, implement its decisions. So that if Senegal is reporting, for instance, we would expect that the committee will ask, well, there's a Taliban case on child begging. What exactly is, the measures that the state has taken in the meantime as part of the state reporting process, so that even if there are no specific implementation hearings to find out what the state has done, the committee can still use that state reporting process as a means of following up on the particular case and the decisions that emanated from them. So, I mean, basically, that's a broad overview of what my thoughts on the complaints mechanism and its importance and challenges. But I suppose I'm open to comments and questions so that we can have a discussion subsequently. Thank you.
Okay, thank you very much, Michael, for that very good overview of the complaints procedure. I think we can already see some of the benefits of this process, but also some regard to some of the issues. But thank you very much for that very good overview. I'm hoping that discussions will spur on later on, and that we can be able to ask questions in relation to some of the specifics of your presentation. Interesting, in the case of Egypt, for example, that although a country had entered a reservation to Article 44 and 45, that the committee still thought that this is something that they could listen to. Very, very interesting perspective from the committee, and I think it should be perhaps the first mechanism to speak to issues around reservations in that context. So quite interesting in that regard. So thank you very much, Michael. So I want to now invite Olivia, to take us through the UN system complaints procedure. And Olivia, you have the floor. Thank you.
Thank you, Anita, and thank you very much for the invitation. I'm going to share my screen with you because I prepared a PowerPoint. And there it is. Okay. Can you see my screen? Yeah?
Yes, we can see your screen.
Great. All right. So I'm going to be speaking about the optional protocol to the Convention on the Rights of the Child on a Communications Procedure, also known as OPIC. And as you know, the Convention on the Rights of the Child has two first optional protocols, one on the involvement of children in armed conflicts, another one on the sale of children, and a third one, which is this optional protocol on a communications procedure. So it's also known as the third optional protocol to the Convention on the Rights of the Child. And maybe just very briefly to tell you a bit about our organization and our work on this protocol. So first of all, our organization Child Rights Connect
Child Connect.
Sorry, we can listen to the French interpreter.
So we are a network of more than 90 child rights organizations all around the world. A lot of national and regional child rights coalitions are part of our network. And we are also a strategic partner on the Committee on the Rights of the Child. We actually, most of the NGOs that were leading the draft of the Convention on the Rights of the Child got together and decided to have a secretariat in Geneva, Switzerland. And that's how Child Rights Connect was created. And our work is really to help organizations on the ground engage with the United Nations mechanisms on child rights, specifically the Committee on the Rights of the Child, but also other mechanisms like the Human Rights Council, the UPR, or with other, with special rapporteurs. And historically, our role has really been to support organizations in their reporting to the Committee on the Rights of the Child. But gradually, we have expanded our areas of work. Another important area, for example, is child participation, so ensuring that children can participate in UN mechanisms, one reporting to the committee, but also in general ensuring safeguarding policies for children. Another area of work is children human rights defenders. And finally, the third optional protocol on the convention, where Child Rights Connect was really with our members, we were really leading the draft of the creation of this instrument, and we are working today to promote the universal ratification of this instrument, and also for there to be a better understanding and a strategic use of this instrument. Last year, we created a dedicated web page to the third optional protocol that I include here, the link, where we really try to gather all the information of the committee from concerning the third optional protocol. So not only the communications themselves, but also all the official documents, guidelines, and we also try to explain exactly how these mechanisms work with graphics, charts. There's also information on the ratification status. And we also have a section for children that we are currently still developing with a group of children themselves. Now, to tell you a bit about the third optional protocol, the OPIC. So it entered into force in 2014. So it is a very recent instrument. And this is important to understand the little number of communications there are so far, and also the fact that very few countries have ratified this instrument 6 years after its entry into force. So basically, the third optional protocol allows for accountability for violations of children's rights, meaning the convention itself and its first two optional protocols. And there are two main procedures. The first is the communications procedure that is actually very similar to the procedure at the African Committee. I will tell you a few differences after, but it is pretty similar to what Michael has explained. And then another mechanism that is different, that doesn't exist in the African Committee, is the inquiry procedure. That it's a specific mechanism to bring grave or systematic violations to the attention of the committee. And for a communication or an inquiry request to be made to the committee, is very important that that it can only be done against states that have ratified this third optional protocol and the Convention on the Rights of the Child, or one of the optional protocols, depending the rights that have allegedly been violated. So this is a key difference with the system at the African Committee, because there can be states that have ratified the Convention on the Rights of the Child but have not ratified the third optional protocol. And in that case, it would not be possible to bring a case or an inquiry against that particular country. So to tell you a bit about the first procedure, so the communications procedure. So this allows children or their representatives to bring individual communications to the committee. It can also be adults who bring communications for violations that happened when they were a child. That's also important to understand, to know. A key difference with the African Committee is that it is not possible to bring collective complaints. So here it is key to identify the victims, each victim for which we want to present the case. And generally, domestic remedies have to be exhausted. I say generally because there are exceptions, but generally they have to be exhausted. It's also possible to request interim measures, so similar to the of a friendly settlement. And also something interesting is that the committee publishes, each time it registers a case, it publishes a little bit of information about the pending cases that it has registered. And this allows for any NGO or, a civil society organization or anyone that is interested in the topic to make a third-party intervention. So that is something, even though the whole procedure is confidential, it is possible to know what are the topics that the committee, that are pending before the committee. So we can already anticipate the topics on which the committee is going to be working on. And so if any of those topics are of interest to your organization, for example, that could be a very good opportunity to make a third party intervention, an amicus. And the committee then adopts a decision, which can be either an inadmissibility decision, or it can be a decision on the merits. And the committee will make recommendations to the state, and these are providently complying with the decision of the committee. Now, except for, in addition to the decision by the committee and all the advocacy that can be done at the national level, also providing information on to states in implementing the recommendations that were made during for the decision. Okay, then the procedure, which I mentioned that is a little bit different from committee. So this is only for grave or systematic violations to the convention or one of the two first optional protocols. And here you do not need to identify the victims. So this is different from the communications procedure. And you do not need to exhaust domestic remedies. And so here, these are the typical cases where you would like to present, for example, when there is all the children in a country are being affected by a situation, or all the children from this minority group or from this city, or all the children in alternative care in this country. So you don't need to identify all the names of those children. It can really be it's really for structural when they're systematic violations on the rights of the child, no? And through this procedure, you can request the committee to conduct an inquiry for grave or systematic violations. And if the committee decides to take up the inquiry, it can conduct a country visit, and where it will meet with different state officials, but it can also meet with the different persons that you can advise as having presented the inquiry. So let's say you present an inquiry on climate change, you could suggest that the committee meets scientists, doctors, or so this is a very interesting procedure because it allows the committee, first of all, to travel to the place, but also to interview and speak with very different persons that can really enrich and help the committee get a better understanding of the situation. It is a completely confidential procedure in the sense that we only know that the procedure took place when the committee publishes its finding reports at the end. But if there is right now an ongoing inquiry, we don't know. That is completely confidential. So it's not like the communications procedure where we could know the pending cases. Here, we have no information up till only when the findings report is published. And state cooperation is really key in using this mechanism, because if, for example, the committee wants to conduct a country visit, it will only do it if the state allows the committee to enter the country. So that's also something to bear in mind. If, for example, you're addressing a situation that is present in several countries in the region, and you want to pick a country, then these are the types of things that you're going to want to pay attention to. Is this state is a state more likely to cooperate with the committee or not? So that's something also to keep in mind. And once the inquiry is finished, the committee publishes a report with recommendations. And again, this report is really key to be used at the national level to advocate for the state to comply with the recommendations. And then there is also a follow-up mechanism where the states have to regularly report on the advancement of the progress in complying with the recommendations. And again, the committee is always there to provide technical assistance in all the steps. Now, so far, the only inquiry report that has been published, so the only concluded inquiry, has been to the state of Chile in South America in 2018, and it concerned children in alternative care. Now, just to tell you a bit about the added value of this instrument. So it acknowledges children as full right holders. So I mentioned that this instrument entered into force only 6 years ago. It's a very recent instrument. So it took, since the convention was adopted in 1989, it took many more years for children to be really acknowledged as full right holders. And it allows for accountable protocol, so it really covers the full range when deciding to bring a case, and to look at the type of right you have in mind. And in another, is always asking for information from the states. And another interesting aspect is that since it's a universal for signature to all the countries in the world, this also allows for the committee to review extraterritorial human rights violations. So we could think of cases, for example, of business and human rights, or let's say that we are in a country in Africa that hasn't ratified the third optional protocol, but there is a company from a state in Europe that has, and this company is violating the rights of the child. That could be a potential situation where you bring, after having exhausted domestic remedies, you bring a case against that European state for a situation that is actually happening in an African state. So that can also be interesting. The third optional protocol also has child-sensitive procedures. So it has some, in its rules of procedures, it has some principles, like, for example, the principle of information that ensures that all the information has to be provided to children in a child-friendly and accessible manner. It has a special methods of work for communications arriving from children, where the children will receive a letter written in a child-friendly language. So there are a whole series of procedures to try to make the mechanism as accessible and child-friendly as possible. And it also allows, of course, the complaints to be reviewed by a group of child rights experts who are going to be guided by the best interest of the child and the children's right to be heard. In terms of the use of OPIC so far, so as I mentioned, it's a very recent instrument. So far, there have been 39 adopted decisions on individual cases, so the communications procedure, 12 decisions on the merits, 17 inadmissible cases, 10 discontinued cases, and 1 concluding inquiry, the one from Chile I mentioned. And in terms of the individual communications so far, so the decisions on the merits have been mainly cases concerning migration and against European states, and a lot of cases of age determination of non-unaccompanied child migrants, non-refoulement, and family reunification. And actually an interesting fact is that a lot of these cases concern actually African children from African countries that migrated to European countries. So it's interesting that the children from the region are actually using this mechanism, even if many countries from the region have not ratified the third optional protocol yet. There have been 17 inadmissible cases, so almost half of the adopted decisions by the committee have been inadmissible. And the 2 main reasons why this is the case are because of the non-exhaustion of domestic remedies and because the complaint is non-sufficiently substantiated. And this is very important it's important to keep in mind that the burden of proof is on the petitioners. So it's really important to, if you are arguing for the exception, for example, of domestic remedies, to really provide concrete arguments, to refer to similar jurisprudence, to not stay in the generalities, because that's not going to be accepted by the committee. And it's not enough to say, this is prohibited by law in my state. You have to show that you actually went to the tribunals, that there were similar decisions. So it's really important to give as much proof and arguments as possible, and especially when when saying which rights have been violated, to explain why those rights have been violated, to refer to the general comments of the committee where they really define the rights, to not stay in the generalities. And it's important also to bear in mind that the committee, through the third optional protocol, is not a fourth instance court. So the committee cannot review the facts and the proofs of the national authorities. It cannot put itself in that position. It can only look if there has been a denial of justice, and if there are specific violations to the convention or to the first two optional protocols of the convention. And finally, 10 cases have been discontinued, and this is actually an interesting aspect of the third optional protocol, because many of these discontinued are actually successful stories. So cases that were brought to the committee, and because they were brought to the committee, this allowed for a discussion to happen at the national, sometimes at the national level, sometimes also with the committee, and the situation was resolved. So we have, for example, in May, and there was a case brought to the committee against Spain because a girl was not accepted to go to school because of her immigration status. And the case arrived to the committee, and thanks to that, the committee spoke to Spain, and the girl was admitted back to school without having to go through the whole communications procedure. So the case was discontinued, a successful story. In terms of the potential of this instrument, so a little bit like what Michael was saying, it really allows for a better implementation of child rights at the national level. It allows the committee to explain the content and to unpack the rights in the convention and the first two optional protocols. And it also allows for situations to generate debates around situations at the national levels of concern that sometimes can be resolved even without having to go through the whole communications procedure. So there is, I told you about the discontinued cases, but there are also, for example, there have been some inquiries where the government decided to take action, even though that inquiry was not taken up by the committee later, but it did help to generate action at the national level. This instrument has a lot of potential to generate structural changes at the national level. And I told you, for example, that the only inquiry report so far was against Chile for children in alternative care. And that inquiry had a very important impact in Chile. First of all, because it put light on the fact that the country didn't have a national policy for child rights. And after the inquiry, the government not only decided to adopt a national policy, and it also changed and it adopted a specific law on alternative care, but it also decided to create an ombudsperson for children, which is in charge of following up the recommendations of the committee, but also in general of promoting and protecting children in the country. So it had really a huge impact. So we could imagine this instrument going forward as a very important instrument in terms of generating structural changes at the national level. And something else to keep in mind is that even though this is a very relevant instrument for child rights violations, it is not the only instrument that children can use. And so when deciding on a strategy for a particular situation, it's important to think, to ask ourselves, what are the specific circumstances of the case, and do I meet the admissibility requirements for an individual communication under the third optional protocol, for example, or maybe I meet, maybe I don't, and then it's easy to know that will not be the best instrument. But also there are situations where, for example, if we're talking about a case of children with disabilities, it might be that a more interesting instrument to present a communication procedure is the Committee on the Rights of Persons with Disabilities. It's all a case-by-case matter, but I'm just mentioning this because it is not the only, and it's not always the best or the most adequate instrument. It really depends on the circumstance of every situation. And something else to keep in mind is that the third optional protocol has two mechanisms, as I mentioned. So the individual communications, but also the inquiries. And so depending on the specific situation, it's important to think, what are the requirements of each mechanism? Because, for example, if I have not exhausted domestic remedies, or if I have, it is really a situation that is structural, where it is hard to identify each of the victims, it might be that the inquiry is a more interesting mechanism than the communications procedure. So this is just some of the questions to keep in mind. And also, I think another question is, what do I want to achieve? What do I want to achieve? And each country also has its own particularities. Some countries are more encouraged to act when it is the universal human rights system that is interacting with them. For others, it's on the contrary. It works better when it's at the regional level. So there are many things just to keep in mind when thinking of what is the best strategy. And there are also some challenges, but with every challenge, there's also an opportunity. So first of all, I mentioned that this is a very new instrument, and it is also an instrument that is not very well known, including by children, and not very used to the date. So at Child Rights Connect, this is actually one of our main areas of work around the third optional protocol, has to do with really providing more information and a better understanding of this instrument. So that's why, for example, we created this special website dedicated to the third optional protocol. But we also are updating a publication with key information of the protocol. We are also engaged in a lot of capacity building sessions, including with children. Some of them have to do more with ratification. Other sessions have to do more with the actual use of the instrument, strategic use. And some of them, as I mentioned, also are specific for children. And we also provide a lot, we're very open to providing advice or to being, to interact with organizations, parents, lawyers, who may be wanting to approach the committee. Now, the fact that there is little knowledge of the instrument doesn't actually help to gain more ratifications. So, and that is actually the other important challenge of this instrument, that so far only 46 states have ratified the third optional protocol. And in comparison, the Convention on the Rights of the Child has been ratified by 196 states. So it's the most ratified international treaty in the world, but its communication procedure is has very limited ratifications in comparison to the convention. And in Africa, there are only 3 states that have ratified the OPIC so far. And the last one was Benin last year in 2019. The first was Gabon, 2012, and Tunisia in 2018. Now, just to show you a bit, so you can make sometimes the visual helps. You can see that more than 80% of the state parties to the OPIC are from Europe and South America, so the countries in dark blue. But you can also see that most of the map is orange. Orange meaning the countries that have not signed and not taking any action on the instrument. So it is still very orange. And here, so this is, with this graph, I want to show you the comparison of the number of ratifications of the third optional protocol in comparison to the first and the second optional protocol of the convention. And we can see that only 20% of the countries that have ratified the Convention on the Rights of the Child have ratified the third optional protocol. So you see them in blue, the 46 OPIC, the bar chart. And in comparison, the OPAC has been ratified by more than 80% of the states parties to the Convention on the Rights of the Child. And the OPSC has been ratified by almost 90% of the state parties to the convention. Now, it is true that the first 2 optional protocols were adopted 20 years ago. So, maybe in 15 years, we will have a lot more ratifications of the OPIC, but let's hope that it will take less time. And so in terms of ratification, in Child Rights Connect, we are also working to promote the ratification of this instrument. We are actually we're finishing a publication which is called Ratification Toolkit, where we provide concrete arguments that civil society and organizations can use to then advocate at the national level for the promotion of the ratification of this instrument. And this publication will be available in a few weeks. We also engage with meetings with states and trying to also understand, on their side, what are the obstacles, what are the things stopping them from ratifying the instrument. Something that we discovered is that it's not necessarily, not all states are necessarily against the instrument. It's just that they might not have a lot of knowledge, or there might be some misunderstandings about the instrument. And we also support organizations and children who are involved in promoting the ratification of this instrument. And here I really take the opportunity of this webinar to, if any of you are working on the ratification, promoting the ratification of this instrument in your country, or if you are supporting other organizations that are doing this, we would be really happy to support you, to see how we can work together to achieve this. And we are also right now in the process of mapping states where there are already some initiatives at the national level to promote the ratification, and to design our ratification strategy. So again, we're really happy to to be in touch with you if this is something you're working on, so we can join forces. And maybe just to end here, to mention a few things that you can do if you're interested in the third optional protocol. So first of all, I would say check our website, because that's where we include all the information from the committee, and we also there are some specific tools that might be of interest to you. There are many graphs where you can really get a sense of the trends of the cases arriving to the committee, also the pending cases, and also, as I mentioned, the ratification status of the countries and by region of the world. We also publish at the end of the session of the committee a summary of the decisions adopted. We also have a database where we gather all the jurisprudence of child rights cases at the UN level. So that could be something that you might be interested in taking a look at. And also, to help disseminate and generate awareness of this instrument in your country, including with children. We have a lot of tools in our website, and some that we're still developing. So, we're very happy for you to use them, or to support you, to also participate in any of these events. Another thing that you can do is promote the ratification of the third optional protocol in your country, or support other organizations that are already working on this. You can use the UN mechanisms to advocate for the third optional protocol, for the ratification, and I mean, for example, the CRC reporting in your alternative report, but also at the UPR. And we're also really happy to be in touch regarding strategies to promote ratification. And I would say you can also follow us, reach out to us, and so we can, as I said, the third optional protocol, the promotion of the ratification and the strategic use is really a key area of work for us. So at Child Rights Connect, you will always find a partner if you're working on this issue, and we'll be really happy to work together. So thank you very much.
All right, thanks. Thank you very much, Olivia, for that, very good presentation. And I hope we've learned a lot from the communications procedure under the OP3. So thanks very much for that. I have a couple of questions, but we will not begin with that now. I just wanted to invite Michael Marwa from Tanzania, so that Michael, I think it would be important to listen to Michael as a child rights practitioner. What are his perspectives on the complaints or communications procedure? Of course, we can already see, I'm sure we all have questions, and I think we can all begin to post our questions on the chat box. But I think I just wanted to get perspectives from Michael Marwa, his perspectives on the complaints procedure. Michael?
Thank you very much, Anita. Greetings, colleagues from Dodoma. Dodoma is the capital city of Tanzania. As you can see, I'm holding my seatbelt. I'm sitting in the car. I'm with my colleagues. We are heading to a field activity in one of the regions called Singida. But I'm happy, Anita, and the hosts for having us, and for letting me participate in this important session. And to begin with, I want to thank you again, Anita, for bringing the experts that just spoken. My namesake Michael, and of course Olivia, very beautiful presentation and submissions. Well, for me, as a child rights, I representing the CSOs working with children on the ground. I'll give my perspectives on the communication procedure, like you rightfully said, Anita. And what I wanted to begin with is that the communications procedures is one of the underutilized mechanisms. As for me, as for my understanding, for the African Charter, but also for the UNCRC. And based on my experience, this is because of I bet on law knowledge, and this is because I've been engaged in some of the sessions where we've been trying to build capacity to local CSOs, especially in my country, Tanzania, on the communications procedure. And I remember the last time the East African Child Rights Network had a workshop in my country on the communications procedure, or the utilizations of the communication procedures, especially Article 44 of the Charter. We came to understand that a lot of our CSOs, our peers, are doing a great job on the ground, talking of the villages and the regions and the wards, but they are not very much aware or their knowledge on the communications or the complaints mechanisms of these two international treaties or regional treaties provide. So when you start looking at this, you find that I remember the last time we had this training, especially when we were when the facilitators were trying to explain something like to do exhausting local remedies is one of the challenges that was seen to be discussed a lot, and had a lot of questions that were asked by the participants. But something else is the needs for, there are a lot of needs that our CSOs or our peers or the child rights organizations are working at local level need in order for them to utilize properly the complaints mechanism that are provided for by the UNCR, by the Committee of the African Charter, but also the UNCRC. And one is, especially with the African Charter, the order of consideration of communication. This is an area where there needs to be a lot of efforts or capacity building for the CSOs, so that they understand what it entails for communication to be considered. And I think my namesake Michael presented it very well. These are the things that, and I wish, I'm sure that, I'm not sure if this session is being broadcasted, but I think if it is broadcasted, there's a lot of knowledge, and if people are following, should be getting. But if it's not, I think it's one of the things I'll advise here, that it should be somehow published, so that people understand. It is an opportunity for CSOs, especially in my country, to listen to what Michael presented and understand, especially the order of the communications on considerations. And something else is procedures of hearing on communications, and also decisions on communication. And Olivia during her presentation said something about most communications are too general. They focus on the generalities, and especially during the workshop that we did, those are the things that you could see coming out from the local CSOs. So when you ask local CSOs not to stay in the generalities, and they've not been taken through about generalities, how these things go about, that's where the challenge is. But again, we also had things to do with who can submit a communication. Can children themselves submit a communication, or can an adult submit a communication on behalf of children, and so on. So for me, from the practical view of this, I want to say that there's very little knowledge, and you could see also from the presentation that Olivia made, there's a need to have efforts to promote the third option of protocol, but also with the African Charter Communication Procedure, regional networks on CSOs needs to do a little bit of work, and especially supporting local networks to make sure that, because these are the people that we depend on to raise issues. And if we see communications are not coming through in the committee, it means that there's something that has not been done at the ground level. So for me, I wanted to bring that and to just bring a few case study. Right now, Tanzania is writing the sixth periodic report to the UNCRC, and CSOs are being involved also in writing the CSO's report. And in the sessions that I've attended, this is something that also has not been very well discussed. I think it's being overlooked. And the issue of age of child marriage, that like the example that was provided by Michael. For us, we have, I know most of you understand that we have the issue that concerns the age of marriage for girls and boys, and it's something that was contested by one of our child rights activists, and we are happy that the case, or we won the case. But now, even after the case, the government directed the legislature to amend the contradicting laws, but this is still yet to be done. So you can see this is an opportunity of maybe the local CSOs to have a communication on this. But because also something like legal aid on how to go about the order of consideration for communications is a gap within our CSOs, our local CSOs. Then you see these things go unattended, and also we don't see communications coming from countries like Tanzania. I know we are. I don't know how we are doing about time, Anita. So generally, that's my perspective. I want to make my submission as that, and over to you, Anita.
All right. Thanks very much, Michael, for already trying to pose certain questions in regard to some of the challenges that civil societies networks within Africa have in relation to the complaints or communications procedure. So I just wanted to now to open the floor, and as I do that, and I think there's some questions on the chat. I think I had a couple of questions for Michael and Olivia. Perhaps I'd begin with Michael. So Michael, in the context of the reservations entered in relation to Egypt, and the fact that the committee agreed to proceed, hearing that reservation. I mean, what happens in regard to implementation of that decision? Noting that, what so far, how does the state proceed and implement a decision against it? We want to imagine that, these processes are sometimes, there's the necessity of ensuring that there's good relationship in terms of, looking at, implementation. So how does, did Egypt, for example, implement this decision in relation to the child? So it would be interesting to, just give some perspectives, because this is an interesting development. Then also in relation to admissibility, in the case of the Nubian case in Kenya, if you could speak to, sometimes the local remedies might be available, but they might actually take time. There might be, if you're able to prove that the the local remedy, is taking time, and how would you advise in relation to admissibility? Some of the circumstances that really you have to demonstrate to the committee that you've taken these steps, and the state still, although those remedies might be available, that the state is not willing, to give the issue a priority in that context. So if you could also speak to that. Then to Olivia, I think Michael was already bringing out some very great perspectives. What are some of the practicalities of bringing communications? Who brings, who initiates, for example, in the inquiry procedure, who initiates the procedure itself? I think also another interesting thing that you mentioned is in the regard to adults who can bring communications when they were children. Does that mean that OP3 can act retroactively in this sense? For example, if a state had not ratified it, and then what happens if you can clarify the instances when adults can bring communications or violations that happen to them when they were children. Then also, Olivia, I think you already had alluded to this. I mean, how do we work together to ensure the ratification of OP3, with the networks that we have, in Africa? Noting that only 3 countries have ratified, within Africa have ratified the OP3. So I think if you can begin with that, perhaps, Michael, and then Olivia, we can listen to you.
Yes, thank you, Anita, for the questions. I will respond to this question, then I'll provide some clarifications as well as regards the inquiry procedure under the African Charter, because that also exists, except it's framed as investigation in a sense. But in terms of Egypt, I think the committee is the treaty body that is, entrusted with the power to interpret what exactly the treaty provisions mean and to guide states in the implementation of those treaty provisions. And ideally, at least in the normative sense, if the committee has provided an interpretation of what it deems to be, against the object and purpose of the treaty, and therefore that reservation would be deemed to be invalid, one would think that that is, something the state would contest, as in many other instances, but that contesting the committee's interpretation is not in itself a basis for refusing to implement, because there's a whole essence of litigation to, present different views, and whoever is the party who loses that particular contestation still has an obligation to comply with the particular, decision of the adjudicating entity. I mean, for me, I think what I found a bit perhaps problematic about the way the committee went about that particular declaration was that it was not something that was, for instance, allowed to be argued and contested. The committee just notified the state party that we have come to a conclusion that this particular reservation is against the object and purpose. I would have wished that they actually asked for a hearing for the state to argue its case on why it's not against the object and purpose. I mean, for the purposes of also justifying why this decision is taken, because it's important for the state to understand that even if you lose, there is a clear justification for why we take this particular decision. And that perhaps would have been a bit more useful in encouraging compliance on the part of the state. But like all international mechanisms, implementation is mostly dependent on the political will of the state concerned, because there are no cohesive mechanisms of ensuring compliance or implementing these kind of decisions. I'm not exactly sure as to the status of this particular communication, because this related to children being arrested and charged before military courts for so-called terrorism or other security charges, and this related to protest. And I'm not sure whether the state of Egypt has actually complied and given some reprieve to this children who were in custody and being charged before military tribunals. But I think that at least theoretically, the state would be, obligated to comply and to give effect to that particular interpretation. In terms of admissibility, I think one of the well-known, if you like, exceptions to the rule of exhaustion of local remedies is undue prolongation. So that even if there are measures that are available within the domestic legal system, but these are taking so long a time to actually, get remedies from, then you can bypass the domestic system and say to the committee, we filed a complaint before the High Court or the Magistrate Court or whichever entity. It's been 3 years. There's been no hearing, there's no decision. And in the meantime, these children are losing a substantial, part of their childhood, which they cannot recover. So that if the situation is such that there is undue prolongation, then there's an exception that the committee makes for such situations that you can bypass the domestic legal system. But you would have to prove that you have actually tried to exhaust those remedies, but that it's because of inefficiencies within the system, or perhaps there is political interference that is, preventing the progression of that judicial mechanism, and that you need to be exempted from exhausting those local remedies. So that is allowed under the Children's Charter. In terms of the clarifications that I wanted to make, the African Children's Charter also has an inquiry procedure, but under the Charter, it's titled as an investigation, where the committee can actually go into a state party to investigate a particular human rights concern involving children. And the African Children's Committee has done this, as far as I know, one time, involving children with albinism in Tanzania. A couple of years ago, when at the height of attacks against persons with albinism, a lot of children were put into temporary housing, which was owned by the government. And there are reports that the housing was inadequate, it was overcrowded, and that some of these children did not even have, adequate sunscreen or some protective gear. So the committee actually did an investigative visit to Tanzania, and they wrote a report, which is on the committee's website, that was shared with the state and broader society to, highlight what the problem is. And one of the recommendations was for the state to reintegrate the children back into society, preferably with family members. And I have done some research on this particular issue, because I had filed a case at the African Court against Tanzania on behalf of persons with albinism. And when I had conversations with persons with albinism in Tanzania, and especially the Tanzania Albinism Society, the consensus was that the government was actually trying to reintegrate the children, but that in many instances, because it was done in such a rush, they did not even have records of the parentage of some of the children, so that it was not clear where exactly they're going to return the child to. And in some instances, the children had lived so many years away from home that they themselves didn't want to return home, because it was not a healthy environment in the first place, in the communities where they felt threatened that they could be attacked and killed, or their body parts taken at any point in time. And since they found a more, if you like, protected environment, there are some kids who are skeptical about whether they want to return back to the communities where they were originally taken from. So that inquiry process exists, except it's just characterized as an investigation. And then in terms of third-party interventions, under the African Children's Charter, third parties are actually allowed to intervene, either as interested parties, in which case they must show the kind of interest they have in the case, or as amicus, which is essentially just a friend of the committee trying to bring certain facts or legal situations to the attention of the committee to help them make a more informed decision based on the law and the facts as well. So those processes exist for other civil society or individuals who might not, really be the applicant in the case, but who think that they can contribute in a way that the committee can make a more informed and well-reasoned decision by having at its disposal either issues of fact or whether there are certain legal arguments that they want to assist the committee with in further elaborating what exactly these rights mean and or should mean in practice. So that is those were just my brief interventions. So thank you.
Okay. Thanks, Michael. Perhaps just two follow-up questions. I think one is if you could just clarify, the investigations or inquiry procedure within the African system. Who initiates the investigation? One, and then, you in relation to the albinism case, Tanzania case. You mentioned that you also instituted a litigation at the African Commission.
Yes.
Was that also running concurrently? How was that? Because how was that running in relation to the inquiry procedure? Did it happen before or after?
In terms of the albinism process, the committee had already done the inquiry. The investigation before we instituted the action at the African Court. And one of the bases of our claim before the African Court was the fact that, there is a committee report that highlights all these, inadequacies in the system and the kind of recommendations that were made. And it does not seem like, this has been taken seriously and effective measures are actually being taken to redress this kind of recommendations. And that perhaps there's a need for a more binding and coercive mechanism like the African Court, which does have a binding powers to bind states in that regard. Perhaps the unfortunate part is that Tanzania withdrew its declaration allowing individual access in the middle of this process. That does not in itself exclude them from liability, but it's just to show that sometimes states become a bit skeptical when there is a barrage of suits against them, because at some point Tanzania had more than 60% of all the cases pending before the court, and I think they might have been overwhelmed and decided maybe we need to take a break. But we waited for the committee to finish first and see what the state would do, and once we saw that they were not really doing as much as we would have wished, we decided to go to the African Court to seek redress. In terms of the investigation procedure, the charter, the language is that the committee may. So there is no, one would think that it's the initiative of the committee, but that there's no prohibition against civil society or individuals requesting or bringing to the committee's attention that this is a situation in this particular country and it might interest you to conduct a investigation in country to actually find out what exactly is the particular situation, engage with government, civil society, and victims, and to find the most state resolve this particular issues. And so basically, I think that there's absolutely nothing that is against civil society and individuals actually making such a request to the committee, but the discretion is with the committee to decide whether they would, in fact, conduct a state visit. And also, depending on whether the state itself is cooperative, because, for instance, Egypt didn't only enter a reservation against communications, they also entered a reservation against investigations. So that, beyond state reporting, they did not want any kind of accountability at all. So you can find states that are not very cooperative and don't want, to be subjected to any form of inquiry or accountability. So that system will also depend on the willingness of that state concerned to actually accommodate, the committee and to facilitate their interaction with government departments and entities, because, you can't just go into a country on your own. As an independent researcher, I can sneak in and go find information, but as the committee is also an international organization with certain political, connotations attached to it, and you don't want to be seen as unnecessarily interfering in the domestic affairs. But
Yes. So just a follow-up, Michael. Interesting that Tanzania withdrew in the middle of the process. So did the litigation continue, and did you rely on jurisprudence from the committee itself?
Yes. Well, the litigation is still continuing. I mean, the state did not respond to our complaint, so we have recently filed for default judgment that if the state is not willing to engage us, then perhaps it's an admission that these things actually exist, and that the court should proceed to give judgment based on what we have presented. We filed 2 years ago, and they have not responded. So it's still proceeding, and hopefully we'll get judgment from the court later this year. And we did use jurisprudence from the committee. We used the committee's report on the investigation mission that they did, as to sort of ventilate some of the issues and the recommendations that the committee gave as well. So that was very useful in our case as well.
Yeah. Okay. Thanks, Michael, for that. And I think we'd love to hear from Michael Marwa if the current state reporting process will also press on the government to follow up on such cases. So thank you very much, Michael, for highlighting and providing further information on the investigations inquiry. So Olivia, you have the floor on the questions.
Thanks, Anita, and thank you also, Michael, for the clarification. So the first question that I wrote down had to do with who initiates the inquiry procedure. And so here it is also at the discretion of the committee. However, the language in the protocol is, if the committee receives reliable information, it can then decide to ask for the state for more information and eventually decide if it opens or not an inquiry, meaning that anyone can submit information to the committee. The committee is the one who, after having requested information from the state and reviewed the information, will take the decision whether to open the inquiry or not. But anyone can submit information for the committee to consider launching an inquiry. I think the other question had to do with adults presenting cases for violations that occur when they were children. And I think it's important to clarify that OPIC cannot be used retroactively. It always has to be for a case brought against a state that is a party to the OPIC, and for facts that happened when the OPIC had already entered into force for the state, the particular state, unless they were continued violations. So given that OPIC is a very recent instrument, I would think more of situations where, if the child presents a case, but then during the case, the child turns 18, or if the person presents the case when he is already or she is already 19, or even, let's say, 25, or it's still, well, no, 25, no, because it entered into force 6 years ago. But it would have to depend on when the instrument entered into force for the particular state and the date of when the facts happened. And the last question: how do we work together to ensure ratification of the OPIC? I think here, at least on our side, for us, at the moment, we're really trying to identify which organizations on the ground are already working to promote the ratification of this instrument. And I think in that sense, maybe one of the first steps would be to know who these organizations are, in which countries they are. They might be some of our members, or they might be partners, or they might be organizations that worked on this issue in the past but are not very active on this at the moment. But I think once we identify them, we can see if there are other partners in the same country that are working on the issue that we can, put them in touch with. And then we can also start to think of a strategy in terms of depending on the situation, the particular situation of the country, and the if civil society is active on this issue or not. And we're trying to really see in which countries to prioritize and to start this ratification strategy. And so I would say to start with, to identify where there is work being done or where there is appetite for this. Maybe there is no work being done on the issue, but there is appetite, and also given the particular context of a country. And then it's hard to say a general path. I think it really depends on the countries, but once we identify a group, we can start thinking of the type of activities that can be carried out jointly, or how we can best support. So that's why I was saying if anyone is working on these issues and listening to us, it would be really great if you can reach out and let us know that you are working on this, so we are aware and we can start to work together.
Great. Thank you, Olivia, for that presentation. I had a follow-up presentation before Felicitas speaks. Felicitas has a question. In terms of, is it expensive, to bring communications, the practicalities of bringing complaints? How long does it take? What are the costs? What do the practicalities of it? If you could speak to that a bit.
Sure. So currently, the average time for a communication to be decided by the committee is 2 years. Having said that, it is possible that as the instrument is more known and ratified by more countries, it could take a bit more time. But currently, that's the average is around 2 years. In terms of the costs, well, the procedure itself doesn't have a cost in terms. You can send it by email, and there is no cost in terms of the procedure itself. There might be indirect costs or costs in terms of the effort and the work of the organizations putting together the case or gathering the information, but I wouldn't say there is a cost that is different than to submitting a case at the national level. There is no fee to present a case or an inquiry, and it can all be done by email. Email is actually preferred than to mailing. And there is no requirement to go to Geneva or to, it's all done remotely. There is a possibility for the committee to conduct hearings, but that is very exceptional. It's usually it hasn't been done till date, and it's usually for situations where the children or a child has presented a case without any representatives, and there is the committee might want to ensure that the best interest of the child is respected, might want to listen to the children themselves, but it's not the usual. And if there was a hearing, it can also be done online again. So there is no there is no travel or mailing cost.
Okay. Great, thanks for that. It's important to get that clarification. So I just wanted to invite a couple of questions from the participants. I have there are two questions, one Felicitas, and then followed by Jennifer. Felicitas, you have the floor.
Thank you, Anita, and thank you. Thank you, Michael and Olivia, for the presentations. I must say that they are an eye-opening in terms of us having the ability to utilize the platforms. Seemingly very technical in terms of what needs to be there, issues around the burden of proof lying with the petitioners, the processes that you have to engage in. I just wanted to appreciate a practical stand view from both of you to say, how then do we balance the lengthy, very lengthy domestic remedy processes with communicating to the committees, both the African and perhaps civil society organizations or children are not utilizing this platform a lot, is also issues around one of the requirements being having exhausted the local remedies insofar as seeking redress is concerned. So how do we balance that, the local remedies and the communication? Lastly, it's around the technicalities. It's very clear that this is a very technical process that we have to engage in. Just to ask issues around admissibility, that if a case is not admitted, is there a chance at all that, from your experience, particularly from you, Olivia, that we can still follow up and make it a case that can come back to the committee and be a case that can be followed through? Because I should think that as much as there are processes or procedures in place, one would not have communicated if there's no rights violation. So that's the bottom line, that there is an issue and that issue needs to be investigated, and perhaps that duty bearers needs to be held accountable. Thank you.
Thank you, Felicitas, for that good question. Jennifer?
Thank you so much, Olivia and Michael. In fact, I'm telling my friends, this is a course in law school, one of those units that you sit down and just listen to, and on children and law. It's such an enlightening session. So for me, I heard you mentioned it, you didn't give into detail, something about child sensitive procedures. If you can kindly, and then I'll reiterate, I think, what Felicitas has asked about local remedies. Right now, we are working with an organization to develop a tool on the African Committee Communication Procedures for Children, a child-friendly version, a tool, an online tool. And one thing, like, as we're working with children to develop it, and one of the comments that I think this, Michael, goes to you too. One of the comments that you're getting from children, they're telling us, the thing is so long, just listen. They're not going through the process, but because we are developing the tool, and we start with local remedies, and then if it doesn't go, these are some of the recommendations, because after this we are going to do a communique to the committee and probably a blurb to the UNCRC. How can we make these processes more easy for children, so that a child doesn't think it's not worth it? By the time I'm done with this whole process, I'll be 18. So I don't know, Michael and Olivia, Olivia, I want you to focus on the child-sensitive procedures, because that's something that we want to borrow from. Like last week, Kenya was doing their submission to the African Committee, and children were given 2 minutes at the tail end of the process to do their submission. It was, we were left wondering, where were children all these 4 hours of presentation, and we didn't hear any children speak. So I would want you to just to learn from you, and then Michael, how can?
All right.
I'll start, and then
okay.
Olivia will.
Okay, Michael, you can start.
But I think in terms of balancing, exhausting domestic remedies as against actually utilizing the regional UN mechanisms, that's the reason why this idea of undue prolongation exists as an exception to the exhaustion of domestic remedies. That one must at least first try to exhaust those domestic remedies. And I don't think there is a specific time frame that one can say this is unduly prolonged. It will be determined by the actual circumstances of a particular case. So that if it's a case that actually requires urgent attention and is taking, let's say, 6 months or a year, and that 6 months could be undue prolongation in one case, whilst in another case, it will not be deemed as undue prolongation. So it will really be dependent on what is the urgent need to address a particular, concern. And if you are very convinced that, this is something that really should have been addressed by the state on an urgent basis, and that the domestic courts are not acting in that regard, then you can always make an application to, the committee and say, well, we know it's just been 6 months, but this is the agency, and this is why, we should bypass the domestic system, because it's an urgent case, but the state is not treating it as though it's an urgent case, so that you can, at least within reasonable time, still be able to utilize some form of remedy that is actually available and willing to, provide redress to the particular child or group of children who are affected by such violations. And I suppose in terms of making it more user-friendly to children, perhaps it also depends on how, the language in which these instruments are drafted. And I think one of the things that we are doing at the Center, for instance, is to have a child-friendly version of the African Children's Charter, to reduce it into a language in which a child of a primary school or high school can understand, this is what the Charter is about, these are my rights, and if my rights are violated, this is how I can get, I may be able to get remedy from the regional or, UN mechanism. So, I think more and more we should be, thinking of how do we reduce these instruments into forms that children can understand without having to give them, a purely legal, technical, document that sometimes even as lawyers ourselves, we struggle to make, the exact definition or what the exact meaning of certain, phrases or, clauses mean. So that is something that CSOs can also, champion in reducing this instrument into more friendly, child-friendly versions to make them more accessible to children. So, Olivia, I think perhaps you are more suited to address the other part of the question.
Sure, thanks, Michael. Maybe just to say on cases that might not be admissible. So the inquiry procedure against Chile was actually first presented as an individual communication. And then the petitioners who were advised by different persons was an inquiry procedure. And they decided to change, so to present the case, really putting emphasis on grave and systematic violations. And it became the first inquiry of the committee to an inquiry, submit a case and information that makes it. And in terms of child-sensitive procedures, so it's important to bear in mind that the committee are to always ensure the best interest of the child, his right to be or her right to be heard, and also in the rules of procedure of the committee. It has a clause where the committee can prevent the manipulation of children by those acting on interest of the child. So that's something to bear in mind. And then throughout the instrument, more accessible and child-friendly. One of these elements is the principle of expeditiousness. Is done fast, where it gives specific time frames for the states to reply to every communication. But then we also have, for example, the principle of information, and this is the other thing that I was mentioning, where every interaction with the child has to be done in a language that is appropriate for his age and maturity, and there and this is throughout the procedure. But even once a decision has been adopted, there is a rule in the rules of procedure under the third optional protocol where the decision has to then be summarized in a child-friendly language for children to also be able to understand the decision adopted by the committee. So now this is in theory. There are some challenges, and for example, this particular last element that I just mentioned, the decisions adopted by the committee being summarized in a child-friendly language, has not been done to date by the committee. And this is actually something that we are in contact with them to see if it's something that we could develop a sort of template together with a group of children for the committee to then use to summarize its decisions. But then there are other things. For example, I was mentioning in the methods of work for the communication, individual communications. The process is not the same if the case is presented by a child than if the case is presented by a representative on behalf, an adult representative on behalf of a child. For example, cases, there is a preliminary admissibility examination that is done by the petitions unit of the committee, where some cases are discarded really from the beginning because they're prima facie inadmissible. So, they're against a state that hasn't ratified the OPIC, or it's something that it's very clear that the case is not going to be registered by the committee. Now, if a child presents a case and that case is prima facie inadmissible, the committee is still going to reply to the child and write a letter in maximum 2 weeks, explaining why the case doesn't look like an admissible case, trying to get more information. So there's really like the committee really tries to give all the opportunities for cases presented by children to prosper. When cases are presented by adults, the bar is a little bit higher. So this is part of what I was saying, what I meant by these child-friendly procedures. This doesn't mean that these procedures effectively make the instrument accessible for children. Actually, only 6 cases were presented by children alone without any representative, and they were all inadmissible cases. Inadmissible prima facie, so not an inadmissibility decision, but cases that were not registered. So there's still a lot of work to do there, and that's also an area that we're very interested in advancing on.
Okay, thanks. Thank you very much, Olivia, for that. I think there's a follow-up question on the chat box. I think Marilyn Njoroge wants to know if you can provide an update on the communication submitted by children to the CRC on climate change. And then if you could give her that update. I think there are two other questions on the chat box. Dagubat Musiwa is asking, the issue of national child protection policies remain weak. And also that local legal remedies, if he's asking whether do we have mechanisms to track cases and backlog to escalate where feasible. It seems some local cases take too long to conclude. So yeah, I think maybe also both of you could, maybe Michael, you could speak to what kinds of cases are viable for communication. I think perhaps if you could give that clarity on the nature of cases that somebody can bring complaints to the regional or the international level. So maybe if you could just briefly speak to those kinds of cases. So maybe I start with Michael and then I'll come to Olivia on regard to the climate change issue.
Yes, thank you, Anita. I think, there is no requirement as to a specific case per se, as long as the alleged violation falls within the instrument, which is in this case the African Children's Charter, or in the case of the UNCRC, the UN Committee on the Rights of the Child, the CRC itself, or the optional protocols. So it really would depend on what is the aim of litigation. So for us, we would be more strategic on what we seek to achieve. And even though there might be an individual victim, we would usually only litigate if we think that this one individual can be used to bring a systemic change. And of course, there are a few instances where if there is an extreme violation against one or two children, we might still utilize, a complaint mechanism, even if it does not bring, broad systemic change, because we are convinced the domestic mechanisms will not address this particular issue well. But otherwise, we would be very strategic in the kind of cases that we choose to present to the regional or international mechanisms, because we want to utilize our limited resources to achieve as much impact as we can. So that we will choose quite carefully. But in terms of the domestic remedies and whether there is a system of tracking, I would think that would be something that CSOs or networks would have to develop and say, well, how many child rights cases do we have in which country, and who is tracking what, and how long are they taking, so that they can determine when they think that a case is being unduly prolonged, and therefore perhaps would require the attention of a mechanism beyond the state. So that would be something that local or regional NGO networks can develop as have a tracker. Also important to know who is litigating what, and what exactly is the process that is going on, and what kind of difficulties they are facing, and then they can make a decision as to whether or not it's a good time to go to a regional or international mechanism to seek redress, because those kind of cases are being unduly prolonged.
Yes, thanks, Michael. Olivia?
Sure. So the climate change case that was presented to the committee, maybe I'll just say a word about it in case everyone is not familiar with it. So it's a case that was presented by 15 or 16 children in September last year against 5 countries, France, Germany, Brazil, Argentina, and Turkey, for violations to the rights of the child and having to do with the countries not taking the necessary measures to mitigate climate change. It's a case that was very it was made public, and there was a lot of media attention because one of the petitioners is Greta Thunberg, the Swedish teenager that you've all must heard about. So this case, we know that it has been registered by the committee because it appears in the pending cases by the committee. And then the whole process is confidential, except that because it's a case that there has been a lot of media attention and that the petitioners have disclosed information, we were able to know through the media that the case was transmitted to the different governments, and that some of them had because this is only what is public, and through the media had provided a response to the committee. So according to the procedures under the third optional protocol, there is now a back and forth between the state having provided a response and then the petitioners responding to that, until the committee adopts a decision either on admissibility or on the merits. But because, again, it is a confidential procedure, we don't know more information than what the petitioners have disclosed in the media. That is this very general information that I just shared with you. I did mention that on average, the committee takes around 2 years to adopt a decision. So we could speculate to have a decision by the end of next year. But again, the only information we know is that has been made public, and we don't, even though we have a very close relationship with the committee, of course, they don't disclose information of individual communications.
All right. Thank you very much for that, for elaborating on the climate change issue. I think we are getting to the tail end of this conversation. I don't know whether Michael Maro is still there. Michael, are you still there? Oh, okay. I think he's on the road. So I think as we conclude, really, I think just one last question to both panelists. If you could just, give us, tell us, what has been really the impact of these processes? Have they had an impact, either bringing wider social, economic, social change in terms of greater clarity on children's rights? Have they brought systemic influence in societies, for greater respect of the rights of the child? So if you could just give us, your perspective on the impact of litigation or the impact of complaints procedures or mechanisms, towards the protection of children's rights. Maybe I'll start with Michael.
Thank you very much. I think litigation has its advantages, as if you like, an addition to other advocacy tools that civil society can use to cover for governments, especially governments that have certain local issues that they would want to address, but are scared of political backlash. So, for instance, in our case against Senegal, there was no contention that the government agrees that there is a problem that needs to be addressed, but also because Senegal is a a country child begging is a very contentious political issue. So that sometimes litigation at, an international fora provides them political backing to say, well, this is not us. This is what the African Union institutions are telling us to do. And that they could, something that would have cost them politically in one respect becomes a more bearable, decision to take, because it doesn't seem to their local constituencies as though it is something that is done willingly by, government to their disagreement. So there can be such, advantages to litigating before international mechanisms. But also it's an avenue for, the mechanisms themselves to elaborate what exactly the rights mean, so that, we can get more, contextual analysis on what exactly a violation looks like, and what should we expect from governments, basically, because our idea of a violation might not be the same as what the mechanism that is, entrusted with monitoring its implementation might deem to be a violation. So that, bringing the communication is a means of actually trying to understand better what exactly does this, monitoring entity expect from state parties, and what can we expect as, redress mechanism from this particular, mechanism. So I suppose one can only say that these are mechanisms that provide useful impacts in many ways, and sometimes even in instances where there is an actual, there is not an actual victory in terms of getting an affirmative decision. Sometimes just, raising the issue is enough to get some attention from the state party. So the communication might even be declared inadmissible, but it still brings that issue to the attention of the state that, well, there's this issue that, we might not have been paying as an avenue worth exploring, and perhaps it's one of the mechanisms that is least utilized by civil society and seeking to hold states accountable. I think we are more used to the state reporting process and providing, alternative reports. But when it comes to the communications and complaints procedure, because we don't understand it so well, we stay away from it. And as Olivia said earlier, it really does not involve much of an extra expense beyond what would be the organization's usual, fact-finding or looking for information to write an alternative report and stuff like that. It's something that you could reduce into a communication, just by finding someone to put, flesh to the legal arguments to the facts that you have, especially if, domestic remedies have been exhausted. And if they have not been exhausted, there's always an avenue to, make claims for exemptions. And perhaps to conclude, to say that at the center, we are always looking to partner with organizations that have domestic, cases that they want to bring before either the African regional mechanisms or at the UN level. So if you have any cases that you think you could use, a partner in bringing the communication, we are always available to collaborate and to work with you to actualize these kinds of cases and to bring them before these mechanisms. Thank you very much.
Thank you. Thank you very much, Michael, for that very good ending. And we hope to also partner with you moving forward. Olivia?
Yes, it's hard to add anything else to what Michael has said, which I entirely agree. Maybe just to mention that for the third optional protocol, so far there have only been 12 decisions on the merits adopted and one concluding inquiry. So it is still a young instrument, and also another thing is that even if there are 12 decisions on the merit, they have mostly been on very, very similar cases. So there hasn't been yet a very, variety of issues being brought and being decided on the merits by the committee. But as Michael was saying, and a bit as I tried to explain during the presentation, litigation is definitely an avenue worth exploring, and sometimes even if there is a case is inadmissible or even if an inquiry is not even taken up by the committee, it can still lead to a national discussion on the issue of concern, and it can help remove obstacles to advance on certain issues. I mentioned, for example, all the discontinued cases brought to the committee, many of which were successful stories. And there was also one inquiry that was brought to the committee against Belgium that the committee did not take up, but that helped generate a national discussion around the Roma minority in Belgium. So for sure, it is an avenue worth exploring. And again, it's different than the reporting procedure because it really allows for the committee to have a focused review on a particular issue. It's really the opportunity for the committee to develop standards, to explain better what the convention means, to unpack the rights. And then it's also the opportunity to give very practical technical assistance to the state in implementing all these recommendations. So I would say that I fully agree with Michael, and I don't have much more to add. Thank you very much.
Okay, thank you very much, Olivia, for your presentation as well, and for clarifying, the questions and the procedures at the UN level. So, colleagues, I think I just want to thank you very much for today, but I just want to hand over to Felicitas to give us her closing remarks. But for me, I just want to express my gratitude and to thank you, panelists, Michael, Nyarko, Olivia, and Michael from Tanzania. I want to thank you very much for your contribution, and I hope to follow up on, better collaboration in regard to the complaints procedure and, of course, advocacy for ratification of the OP3. So thank you very much. Felicitas, are you there?
Thank you so much, Anita. And thank you to the panelists. Like we said, this was an eye-opener, particularly because issues to do with communication, you find that they're very technical because there isn't so much in terms of what the for having been a part of the meeting. We really do appreciate it very much. What I'm taking from the session is that firstly, we need more of these sessions to unpack the concepts, but also to utilize what other jurisdictions have done in terms of setting precedents on these issues. We also need more to unpack particularly issues to do with children having submitted communications. Earlier on, when Marilyn was asking about the climate change communication by children to the CRC committee, those are some of the issues that we would want to see more happening. So perhaps we need to be facilitating the child versions in terms of the communication as civil society organizations. I know that Child Rights Connect has something in place, and perhaps it's a call for us as the CSO Forum that we need to see that we also do have one for ourselves. issues around admissibility and the burden of proof by petitioners. I think one of the things that we really should perhaps recognize and be honest about it is that as civil society organizations, we do so much, but we still have gaps and challenges insofar as documentation of the so much that we are doing to be done effectively, such that it becomes easier to produce this evidence, and it becomes easier to make sure that our communication is accepted because it has all information that is needed. So perhaps we invest more on documentation. I think COVID-19 has facilitated for us to be able to do this better because now we are able to record stuff, so it's easier to then go back to that recording and get more information. But it's also very clear that we need to forge more partnerships, more allies and partners, particularly with your Michael Nyago at the academia, people who would, guide us to do some of these processes properly. Yes, Olivia spoke about the cost sometimes is the effort that we put in drawing those incidents or the communication cases. So perhaps that's where we need to invest as well, forge partnerships with able organizations that can then facilitate for us to be able to do what we need to do, so that at country level, we make sure that we've exhausted all the domestic remedial processes, but also that we have a solid document that can be submitted before the committees. This is a partnership to do more together, and we hope that as we reach out to you, you'll be able to assist us to get this momentum that we've built today ongoing, and that we can help to hold ourselves accountable as the people that need to be bringing this submissions, but also that we can hold duty-bearers accountable and the committee. I mean, taking 2 years, I think that's a very long time when we know that committees actually do sit. With the CRC committee, it sits thrice a year. The African committee sits twice a year. So what stops the committee from investing in some of these communications that have been brought before them, so that justice is meted on time. So thank you so much, and we'll continue to be in touch. And to all civil society organizations here present, please, let's utilize this platform, because now we don't have an excuse to say that state party reports have not been submitted for how many other years, but we do have alternatives to still bring the issues to the fore. Thank you so much, Anita, back to you. And thank you, Anita, for moderating the session so well. Back to you, Anita.
Okay, thank you very much, Felicitas, and thank you all participants and panelists. We do wish you a nice day. I think that's it from me, really. Just to say thank you, and I think we hope to, for just as Felicitas has said, let's follow up on how we can work both with the Center as well as the Child Rights Connect a bit more aggressively, now that we are aware. I think if you also want their contacts, please do not hesitate to reach out to us, the CSO Forum group, so that we can, directly put you in touch with both of them. The center is very well esteemed as an academic institution, as also the Child Rights Connect also, working really, having, the bird's eye view of, the global context in relation to, promoting the rights of the child at that level. So thank you all, and we wish you all a good day.
Thank you so much, guys. Thank you so much for this. Remember, we have another panel for children. This is exclusively for children by children. from 3 o'clock East African time. And then tomorrow we have Center for Human Rights, and they're going to be talking about children's rights in the digital environment. Please, if you have not registered, register for the two. And remember, everything that we are going to do, conversations we are having here, we are compiling it into a communiqué that we are going to submit tomorrow to the committee, to the African Committee of Experts on the Rights of the Welfare of Children. And we will see how we can be able to link with Olivia and maybe send a copy to the UNCRC just for them to learn on some of the issues that we are facing in Africa. But thank you very much for joining in. Thank you.